The justice system, when an ever-changing yet founding stature of our country, has evolved greatly over the centuries it has existed. We've even had the opportunity to witness it over our lifetimes. When adults are tried for their crimes, we deem it as normal. When juveniles are tried, however, we argue whether or not the punishment is too lenient or too harsh. Before delving into the different angles to approach juvenile conviction, it is first important to understand the difference between juvenile court and adult court. A major difference involves the primary objective of each. Juvenile court focuses on rehabilitation so the minors convicted can become civil members of their communities when they are free. Adult court, in contrast, finds adults guilty of their crime and focuses on punishment. There are also differences in the process minors and adults go through. Minors typically will not be detained immediately after the arrest, and there is no jury during the trial. Juveniles are also typically put on probation. With this information, we can now start to contemplate the validity of these laws and if they are used correctly in practice. We must ask ourselves if trying a minor as an adult is more useful for rehabilitation purposes, or if it hinders the minor since the primary objective in adult court is punishment. It's also crucial to consider the consequences of being tried as an adult and the impact it will have on both the minor and those surrounding them, as well as the precedent it sets for society. As we delve into history of trying a minor as an adult and discuss some recent cases, it is important to keep all of this in mind.
In the late 18th century, all juveniles were being tried as adults, and due to this, they would face the full punishment for their crimes and be put in jails with other adult criminals. In 1825, Thomas Eddy and John Griscom organized the Society for the Prevention of Papirism, which helped juveniles from being tried as adults, and this led to the New York House of Refuge being opened up, which was to help the poor youth who were deemed to be on the path of delinquency. And this was the unofficial start of the juvenile justice system. In the years to come, more and more of these facilities kept opening across the country. But these houses of refuge quickly became overcrowded with worsening conditions and abused staff. And due to the public school movement, more and more people were arguing about the emphasis of education and reform to help educate the youth of the country. In 1899, Illinois created the first juvenile court, which tried juveniles as juveniles instead of adults. This radical change started the revolution of these courts being opened across the country, and eventually these courts unified under a juvenile justice system. This helped juveniles to become reformed due to the focus on rehabilitation over punishment. And these court hearings were largely informal, and they had no jury, and it was up to the discretion of the judge. Eventually, though, in the 1950s and 60s, concerns about the large disparity of juvenile courts because of the power of the judge became a problem, and the Supreme Court made a series of decisions to give the juvenile courts consistency and to help formalize the juvenile court and give the juvenile protections and the right to counsel. For serious crimes, they were moved to a more formal setting. In the 1980s, there was a rise of juvenile crime, so the states passed punitive laws which gave mandatory sentencing for certain crimes and automatic adult transfers. In the 1990s, there was the tough on crime phase, which incarnated more youth, which led to correctional facilities becoming overcrowded. In the early 2000s, after the tough on crime phase, the courts focused again on rehabilitation, and they decreased the laws for the mandatory sentences. In today's world, there's a larger emphasis in juvenile court for rehabilitation over punishment once again.
In early 2019, a 12-year-old boy in Uvalde, Texas was charged with capital murder for breaking and entering into the home of 24-year-old boxer John Dwayne Vermeer. His girlfriend made the call to 911, reporting someone had broken in and shot him. According to the girlfriend, the boy had been staying with them for the past 2 months and frequently slept on their couch. She also made note that he had threatened others before, including her own son. The boy's name has yet to be released, and very little is known about both his family life and previous living situation. He is at risk of facing up to a 40-year sentence, even though he is being charged as a minor, and is currently being held in a juvenile detention center. He is in partial luck, thanks to the Supreme Court case from 2005, which ruled it is illegal to charge juveniles with capital punishment. He is also protected by Texas's cutoff age to charge a minor as an adult, which is 14. Although these laws seem rational, there is still a lot of concern for the legislation surrounding juvenile law and the age of conviction. This is especially prevalent in Texas, where prosecutors are known for seeking the highest punishment and charge possible. Many professionals with experience in both brain development and law have voiced their concerns for this case. Robert Durham, the executive director of the Death Penalty Information Center, stated, "If a child has committed an adult crime, then almost by definition, you know that there are serious problems in that child's life. A kid who commits murder isn't thinking about the law. He or she is caught up in some very complicated set of emotions. We're dealing with somebody who has been seriously abused or neglected or is mentally ill." Mandy Miller, a defense attorney who represents juveniles convicted of capital murder, also commented on this case. "The justice system has to catch up with science, which says that brains are not fully formed until we're in our 20s. Male development of the brain is even behind the females. A 12-year-old, this is not somebody who can comprehend the gravity of his actions. That's assuming he isn't already damaged. This case, with many others alike, leads us to ponder the validity of the laws surrounding juvenile conviction, and if we can truly put our trust in a system that appears to be so outdated."
One major reason we have seen adolescents charged as adults within the last few years is due to the influx of school shootings, and more specifically speaking, high school shootings. This means that most of the time, teenagers under the age of 18 are committing crimes, such as murder and attempted murder, that often get them charged as adults. On November 30th, 2021, at Oxford High School in Michigan, 15-year-old Ethan Crumbley brought his father's 9mm Sig Sauer semi-automatic pistol to school, shooting and killing 4 classmates and injuring 6 more and a teacher. Crumbley is being charged as an adult and is facing charges such as 1 count of terrorism causing death, 4 counts of first-degree murder, 7 counts of assault with the intent to murder, and 12 counts of possession of a firearm during the commission of a felony. His parents have also since been charged with 4 counts of involuntary manslaughter. There is a possibility that more charges can be added as the case continues. Since Michigan law doesn't allow for adolescents to be spoken to without parental consent, the police have been stonewalled from talking to Ethan. However, the sheriff's office has been informed of Crumbley's concerning behavior the day before and of the shooting by 2 different teachers. Additionally, investigators found 2 videos on the suspect's phone from the night before the shooting. In these videos, Crumbley talked about shooting and killing students at Oxford High School. So, the question is, what constitutes a crime bad enough for an adolescent to be tried as an adult? In this case, we know that Ethan Crumbley has also already been charged as an adult, and investigators have no intentions of treating him as anything but. According to CNN, this attack is the deadliest U.S. school shooting since the 2018 Santa Fe high school assault that left 8 students and 2 teachers dead. The question now is whether or not it's morally acceptable for Ethan Crumbley's actions to be viewed as taken from an adult standpoint or from an adolescent's.
There's so much controversy when it comes to juveniles being tried as adults that it makes us question whether or not the punishments are deserved or necessary. Changes in juvenile punishment were carried out for the benefit of the criminal, as they are deemed to not have the same mental capacity as adults. But over the years, the judicial system appears to drift away from that vision and punish juveniles based on the severity of the crime. This could ruin the juvenile's mental state because they would have to carry the burden of being a criminal for the rest of their lives, not to mention the effect it would have on the parents, as they would potentially be judged as horrible parents for raising a criminal. If this controversy is not solved within the next few years or so, we may never see the end of the backlash of a juvenile's punishment for their crimes. We hope that the judicial system has a set plan in mind for juvenile conviction and that it follows through with it completely. While we mustn't overlook the severity of the crime, we must take the well-being of juveniles into consideration, as they are still developing and may not have the same level of maturity as an adult.